Hi all, thank you for joining us. Welcome to the third installment in the Spring 2019 Trends in Behavioral Health webinar series. This series is a collaboration between Epstein Becker Green, Nelson Hardiman, and the Behavioral Health Association of Providers. Today's webinar is titled Marketing Best Practices in Light of the Support for Patients and Communities Act. Before we begin the presentation, please note that today's webinar is being recorded and participant phone lines will be placed on mute throughout the program. You are welcome to submit any questions directly to the presenters during and after the webinar. Their contact information will also be displayed at the end of the presentation for your reference. In 2 to 3 days, Epstein Becker Green will email all registrants a link to access a recording of today's program and PowerPoint materials. I'm pleased to welcome today's presenters. Kathryn Edgerton, a partner at Nelson Hardiman in the Regulatory Compliance and Transactional Practice Groups, and Anjali Downs, a member of the firm in Epstein Becker Green's Healthcare and Life Sciences practice. At this time, I'd like to turn the presentation over to Kathryn.
Thank you everyone again for joining us today. This is going to be a great program. Today we will give you an overview of the Eliminating Kickbacks and Recovery Act. We will discuss relevant terminology. We will discuss exceptions to EKRA, as well as some related California laws. Then we will turn to the existing fraud and abuse landscape, how EKRA fits into that existing framework, how EKRA applies to laboratories, and then finally what companies should do now. And then at the end, we'll have time for questions, and we're happy to answer those. So let's go to the next slide. Why does this matter? So as background, prior to the Affordable Care Act and the Mental Health Parity Act of 2008, addiction treatment was largely a cash pay business. And that meant that while there were licensing and certification requirements enforced by state regulators, it was not an area where claims were being submitted to insurance or paid by insurance. As a result, the industry was much smaller than it is today. And anybody who's involved in the industry is well aware that the number of providers and the number of claims have grown explosively as a result of the fact that the Affordable Care Act includes substance use disorders as part of the minimum essential coverage that health plans are required to have. While this growth has been wonderful from a perspective of expanding access to care for people who have an addiction and need treatment, from the perspective of regulators, it's newly in the spotlight in the last few years. So when this was a cash pay business, there just really wasn't the level of incentive for investigating abuses. As the insurance companies started to try to wrap their hands around the explosion in the volume and amount of insurance claims, their first response was to look to fraud risk and also medically unnecessary services, and so that's what the industry has been experiencing for the past few years. The state regulatory programs here in California and also in other states are frankly playing catch-up, and they were not designed and had not allocated resources for the industry in its current growth pattern and volume. Nationally, state legislatures are under pressure to tighten laws. Also, each of the health plans has what's called a special investigations unit, and the special investigation, that term is just another term for a fraud and abuse investigation. So that's fallen to these units within the health plans to examine whether there are medically unnecessary claims or other fraudulent and abusive practices, and to deal with those internally by disputing payment, demanding recoupment, and in some cases, which is what we're going to be focusing on, building cases to be referred to criminal prosecutors. Finally, there's a whole host of patient safety issues and a lot of negative attention that has arisen around the country as a result of patients who have been injured, who have died in addiction treatment facilities, or who have overdosed after discharge from facilities. So there's a heightened level of attention from a patient safety perspective. Because of the heightened scrutiny and serious patient safety issues, it has never been more important to focus on compliance issues. So let's go to the next slide. So we're going to just briefly talk about, the enforcement players. You can get a perspective of the landscape. There are a wide variety of distinct enforcement players that care about fraud and abuse, including state regulators, health insurance company, SIUs, and federal regulators. Just to give you a sense of how problematic the current environment is, it's worth noting the way federal regulators have stepped in. We've seen examples for years of federal enforcement stepping in to support state regulators in areas where fraud and abuse does not seem to be adequately addressed by state regulators. Anytime you see congressional committees convening to talk about abuses, as we have seen in the addiction treatment space, that should be concerning to everyone in the industry. It flags from the perception of federal and state regulators that there's a problem. And again, as I previously mentioned, the problem may be falling in the first instance to the health insurance companies to deal with it, but rest assured that the government is actively looking into this, troubled by it, and they will make examples of some companies for abusive practices in the future, including enforcement of EKRA. And so I'm just going to briefly, if you could just show the next two slides briefly, I just wanted to give you a visual to show you these are some of the state and local investigating agencies in California, and there's similar agencies in all other states. And then also the next slide, this one is examples of the federal investigating agencies. So there's lots of agencies that are interested in these issues. All right, so let's move on to the next slide. So on October 24th of last year, President Trump signed into law the Support for Patients and Communities Act, a comprehensive bill designed to address the current opioid crisis. The act, which received wide bipartisan support in Congress, is a follow-up to the last bipartisan opioid crisis-focused legislation, CARA. Like CARA, the Support Act takes a sweeping aim at the opioid crisis, focusing on numerous aspects of opioid prevention, treatment, and recovery, and expanding various types of coverage, use of telemedicine, and electronic prescribing, among other things. Section 8122 of the Support Act is referred to as the Eliminating Kickbacks and Recovery Act of 2018, or EKRA. And this is what we're going to talk about. It's of particular note for addiction treatment providers. EKRA is codified at 18 U.S.C. Section 220, and it was effective upon enactment, meaning October 24th, 2018, and it applies to both public and private, meaning commercial, health benefit programs. Let's go to the next slide. Unless an exception applies, EKRA prohibits the following: knowingly and willfully soliciting or receiving any remuneration, including any kickback, bribe, or rebate, directly or indirectly, overtly or covertly, in cash or in kind, in return for referring a patient or patronage to a recovery home, a clinical treatment facility, or a laboratory. It also prohibits paying or offering any remuneration, including any kickback, bribe, or rebate, directly or indirectly, overtly or covertly, in cash or in kind, to do one of the two following things. One, induce a referral of an individual to a recovery home, clinical treatment facility, or laboratory, and in exchange for an individual using your services of the recovery home, clinical treatment facility, or laboratory. And we're going to talk about all of this in detail in the next few slides. So violations, one thing to note about this law, this is very important, violations of this law may result in a fine of up to $200,000 and imprisonment of up to 10 years for each occurrence of a violation. So there's a lot more teeth to this law than there have been in some of the previous laws, at least here in California. So let's move to the next slide. I'd like to just highlight a few definitions under EKRA. A clinical treatment facility means a medical setting other than a hospital that provides detoxification, risk reduction, outpatient treatment and care, residential treatment, or rehabilitation for substance use pursuant to a licensure or certification under state law. Also, a recovery home means a shared living environment that is or purports to be free from alcohol and illicit drug use and centered on peer support and connection to services that promote sustained recovery from substance use disorders. This definition is broad enough to include sober living facilities. So let's go to the next slide. Some more terminology and concepts that are commonly used when discussing regulations remuneration refers to anything of value in exchange for something. It's that simple. It could be cash equivalent. It could be things like gifts, vacation, covering expenses, providing transportation, paying for meals. This term is often used in context with patient inducement. Within addiction treatment marketing, we often see inducements to get patients to come to a treatment program. A kickback refers to giving something of value in order to induce a patient referral into a program. It can include anything given from one party to another in order to generate a referral, whether from an individual to an organization to an individual to an individual, or an organization to an organization. Finally, patient brokering occurs when one party sends a patient to another party in exchange for something of value. For example, an IOP program may send a patient to a recovery residence in exchange for financial consideration. Let's go to the next slide. We're going to talk about a few exceptions that are relevant to the addiction treatment industry. So EKRA sets forth 8 exceptions to its prohibition, and I'm just going to focus on 2 of them today that are the most relevant. So EKRA has an exception for payments made by an employer to an employee or an independent contractor who has a bona fide relationship or contractual relationship with the employer for employment if the employee's payment is not determined by or does not vary by A, the number of individuals referred to a particular recovery home, clinical treatment facility, or laboratory, B, the number of tests or procedures performed, C, the amount billed to or received from, in part or in whole, the healthcare benefit program from the individuals referred to a particular recovery home, clinical treatment facility, or lab. So this means that bonuses, and we're happy to answer questions about this if you do have questions at the end, but this means that bonuses should not be paid based to employees based on successful admissions, which is a common practice in the industry, and bonuses shouldn't be related to the value or volume of referrals of patients. Employers can pay bonuses for other things. They can be based on the efforts of the employee, other factors such as client satisfaction, or just in general the overall success of the business. But it cannot be on the value or volume of referrals or successful admits. Please note that payment to employees and independent contractors for admission and marketing services must be based on the fair market value of the services provided to the facility at a commercially reasonable rate. So sometimes, clients try to get around, paying the bonus, but they just pay a really high salary to their employees. So if you're paying a really high salary that wouldn't be considered fair market value, that the inference there is that you're actually paying that employee for the value and volume of referrals and not on the work that they're doing. And if you're unsure as to what constitutes the fair market value for services at a commercially reasonable rate, you may want to hire an independent valuation expert to ensure that you're not running afoul of the new law. Let's go to the next slide. EKRA also has an exception for payments pursuant to a personal services or management contract, and they have to meet certain requirements. So there's 7 requirements. The first is that this agreement has to be in writing and signed by the parties. The second is that the agreement needs to cover all of the services provided for the term of the agreement and must specify the services to be provided. The third is that if the agreement is intended to provide for services on a periodic, sporadic, or part-time basis rather than a full-time basis for the term of the agreement must specify exactly the schedule of intervals, their precise length, and the exact charge for such intervals. So what we would recommend here is making sure that you have, if you're contracting with a third party for marketing services, that this third party actually, and it's not like a full-time job, then they need to be recording in an activity log exactly what they're doing for you and how long it's taking. Let's go to the next slide. So the remaining requirements for the contract, the term of the contract must be for at least 1 year. So you can't enter into a contract and then sort of cancel it every quarter or every month and just renegotiate it. It must be for 1 year. Because otherwise the suggestion is you're changing the contract based on the value or volume of referrals, and that would be violating the law. 5, the aggregate compensation paid over the term of the agreement must be set in advance, must be consistent with fair market value in an arm's length transaction, and it must not be determined in a manner that takes into account the volume or value of any referrals of business otherwise generated between the parties. The services performed under the agreement also must not involve the counseling or promotion of a business arrangement or other activity that violates any state or federal law. And finally, 7, the aggregate services contracted for must not exceed those which are reasonably necessary to accomplish the commercially reasonable business purpose of the services. So again, items 5 and 7, that's referring to the fair market value of services and must be commercially reasonable. The same as with an employee, is what I said before. You may want to get a valuation from an independent expert to give you a piece of paper that's telling you what you're paying is fair market value and reasonable, so there can be no inference that you're paying for referral. So based on this particular exception, addiction treatment facilities are permitted to contract for marketing services, but you just need to make sure that you're meeting all these 7 elements in your contract. And the whole point of this provision is to prevent patient brokering. And so that was, the focus of this new federal law. And with the passage of the new federal law, it's become more important that all marketing be done on an efforts basis as we anticipate more federal enforcement focusing on marketing relationships in the year to come, and we'll talk about that more later. So next slide. I just want to talk about these concepts of fair market value and commercial reasonableness. Get a lot of questions on this. So fair market value refers to what other employers are paying in the same marketplace for relevant services. It takes into account the geography of the employee, which impacts cost of living. It also takes into account the current state of the market with regard to people available to perform the particular function. So if it's difficult to find a marketer for a particular area or specialty, then that fair market value will go up. Let's go to the next slide. With regard to commercial reasonableness, 2 things are considered. One is the aggregate payment for the services consistent with practices in other places. Other places could mean similar employment circumstances or other similar geographies. And when considering the aggregate employee or contractor compensation, and in the absence of referrals, would the relationship actually make sense? And again, is it consistent with what others in the industry are doing? Let's go to the next slide. I just wanted to address bed vouchers quickly. So any sort of quid pro quo arrangement between businesses with regard to patient services is considered a kickback and prohibited by EKRA. The issuance of bed vouchers by a treatment program to a sober living enterprise or transitional living program is also considered a kickback and a fraudulent insurance practice if the treatment program is billing an insurance payer for services. This quid pro quo arrangement, in this quid pro quo arrangement, the treatment program will receive a referral from a sober living facility in exchange for the sober living receiving the monthly rent for the patient while they are in treatment. So this type of arrangement has been actually the focus of several prosecutions in multiple states. Let's go to the next slide. I also wanted to address call centers. Call centers are a unique phenomenon in the drug rehab industry. we work across, at Nelson Hardiman, we work across the entire healthcare industry, and really there's no other vertical within healthcare that seems to use call centers as much as the addiction treatment space. They're perfectly fine in concept. The problem is that we see that there's a dependence upon call centers for patient flow, and call centers are charging on a per-patient basis for their referral. So again, this goes back to the same basic point. Paying a call center on a per-patient basis is not legal. Treatment programs can operate and own their own call centers subject to avoidance of deceptive marketing practices, but paying outside call centers on a per-patient basis for the value or volume of referrals is not permitted. Insurance companies and the government agencies that review the practice are not going to tolerate paying per patient. It will be treated as a form of fraud and abuse within the drug treatment industry. So if you pay a regular, commercially reasonable rate for a call center to try and generate patients, and you pay the rate irrespective of whether there are 0 referrals or 100 referrals in a particular month, as long as it's commercially reasonable, that would work under the exception to EKRA that we mentioned with the 7 factors. If you're using call centers that are charging you on a per-patient basis, now is the time to relook at and reconsider that relationship and make sure that it's compliant with the new law. Let's go to the next slide. EKRA also, this is the second important thing that I wanted to discuss about EKRA. They also prohibit offering anything of value to patients in exchange for using services of the recovery home, clinical treatment facility, or lab. So programs may not pay patients for travel to the facility. This is a question that we get all the time. Specifically, we do not recommend offering discounts or subsidies for plane tickets because the discount or subsidy could be considered an inducement to the client to use your services. That being said, in certain cases, if the client has a genuine and documented financial need based on a consistent and reasonable policy, then it may be permissible to establish a financing agreement under which the client, preferably the client's family as a guarantor, agrees to repay the full price of airfare over a set period of time. It is important that the company actually pursue payment for transportation services from the client based on the agreed upon repayment schedule. If the program signs these agreements with clients and then does not pursue payment, then these agreements can be viewed as just simply form over substance and could potentially actually be viewed as evidence that the company was inducing a client to receive services by paying for flights and transportation. Also, you need to be careful of lending laws within your state. There may be specific requirements in your particular state. Additionally, programs should not waive deductibles, co-insurance, or co-payments without determining whether the patient has a genuine financial need. Based on our experience in other areas of healthcare, we believe that it is reasonable and defensible to offer clients a discount if they have a genuine and documented financial need. It is important to assess each client's financial need and apply your policy in a reasonable and consistent manner. As a practical matter, you should monitor how many people are actually receiving financial assistance based on your policy, and if the percentage is too high, you might want to review the standards being applied. If you're going to reduce patient costs for those who have limited financial means, you should keep the following in mind. You should adopt a clear, consistent, and reasonable standard for reducing patient costs, and you could base this determination on a sliding scale tied to the federal poverty guidelines that are set each year by the government. Programs should require patients to complete an application for assistance, and programs should collect documentation verifying the patient's financial needs. If the patient qualifies for assistance, the program may discount or waive the deductible, copayment, or coinsurance, and may reduce fees according to the program's set standards. Some practices I like to highlight that raise the risks include routinely offering discounts on fees to all patients, routinely waiving deductibles, copays, and coinsurance, charging inconsistent rates different payers, meaning charging one rate to the insurance company and one rate to cash pay, and then just insufficient documentation in general. It is important that treatment providers keep good records showing why you've discounted or waived fees for patients. And finally, outpatient programs should not offer free or reduced rent to sober homes that they operate if the patient attends the IOP program. It has been a fairly common practice in addiction treatment to offer housing at a reduced or no cost. For example, an outpatient program may offer free or reduced rent at a sober home that they operate if the patient attends their IOP program. In many cases, these services are offered out of a legitimate and compassionate concern about the person who does not have a secure place to stay that will support their recovery efforts. Unfortunately, these arrangements give the strong appearance of kickbacks and inducements because it is assumed that the patient will be attending the IOP with the expectation that housing will be provided and that housing may be something that the patient would not otherwise be able to afford. I'm happy to answer questions on any of that at the end. So let's move on to the next slide. California, I want to talk about a few California laws. California also enacted recently SB 1228, and that went into effect at the beginning of the year, and it specifically prohibits patient brokering. DHCS, the California Department of Healthcare Services, recently in the last month issued their information notice, which provides guidance regarding complying with SB 1228. And I expect that there will be other similar laws around the country in other states. So DHCS provided some examples of what would violate SB 1228, the law against patient brokering. So one is payment of referral fees, meaning very similar to the federal law, soliciting or receiving anything of value, directly or indirectly, overtly or covertly, in cash or in kind, in return for referring a patient to a licensed or certified alcoholism or drug abuse recovery and treatment facility. The second example they gave was payment of commissions or bonuses, which is what we were talking about before with employees. So any form of commission or bonus paid to treatment facilities, owners, partners, directors, employees, and other shareholders in exchange for client referral to a licensed or certified treatment facility is prohibited. And next is paying clients to attend a program. This is a practice that was occurring with some marketers in the industry. So it's clearly illegal to pay a client to attend a program or to recruit them. Specifically, DHCS called out recruiting potential clients at AA meetings and other types of similar meetings and paying them to attend. They also address call centers. So they give an example of providing anything of value to a call center or company in exchange for a client referral. And finally, they address patient brokering directly. It's prohibited to sell potential client information to bidders in order for the bidder to secure a potential client's enrollment at a licensed or certified addiction treatment facility. And this law has a civil penalty of $2,000 for each occurrence of violation of the law, and the department may also suspend or revoke a license and deny new applications for licensure if there's a violation of this law. Let's go to the next slide. This is important in California, and I expect some more laws around the country. There's new disclosure requirements. So there's new disclosure requirements that have to do with ownership or control of or financial interest in a recovery residence, and that means sober living facility. And also any contractual relationships with an entity that regularly provides professional services to addiction treatment facilities. So those could include, drug testing laboratories, hospitals, clinics, counseling centers, transportation, and sober living facilities. So DHCS is requiring that you actually call out any relationships that you have with any of these types of providers. And so that will help, with investigations. Let's go to the next slide. Now, just briefly, I'm not going to go through this in detail, but even though there's this new law, EKRA, and SB 1228 in California, there were already prohibitions in California law that existed under California Insurance Code Section 750 and Section 1871.7, as well as the California Health and Safety Code Section 445. All of these prohibit paying for clients and paying for referrals. So any current investigations that are under, this state law in California or state laws that similar ones in other states, if there's current investigations, now the investigators can also add on, violations of EKRA, which came into effect last year. So I expect that in the next year we will see some enforcement on all of these laws. So with all of that, I know it was a lot. I'm happy to answer questions at the end. I wanted to turn it over to Anjali, and she will discuss the existing fraud and abuse landscape.
Thanks, Katie. So I wanted to spend a few minutes discussing the existing fraud and abuse landscape and how EKRA fits in, and especially how it relates to the anti-kickback statute, in part because there are similarities between the anti-kickback statute and EKRA, but also because the anti-kickback statute has been in existence for a long time. There's a lot of law and regulation around it and guidance around it, and so it may help give us guidance on how to kind of interpret EKRA, especially right now when there's very little information. And while we certainly will expect regulations, I think, in the future, in the meantime, we're kind of left with, so what do we do now? And we can look to the anti-kickback statute maybe for some guidance on that. Things that you should know that Katie touched on, fair market value, commercial reasonableness, those are things that are within the anti-kickback statute and heavily discussed. There's a lot of guidance provided on that, and we work with independent evaluators all of the time to address those issues. So those concepts are very I don't want to say clear, but are very familiar to the healthcare industry as a whole, and so that will provide guidance for us as to how we apply them in this context. So the anti-kickback statute is also a criminal law that prohibits the knowing and willful payment of remuneration to induce or reward patient referrals or the generation of business. And as Katie already explained, remuneration can include anything of value and can take many forms besides cash. So from a kickback perspective, it's historically been focused on referral sources or those who are in a position to induce a referral. And it's also been focused on patient inducement, but it has been widely used to enforce relationships with physicians and vendors and the like. The anti-kickback statute only applies to items and services payable under federal health care programs. And like EKRA, the anti-kickback statute has safe harbors and exceptions, some that are similar to EKRA and some that are different. What is different in the anti-kickback statute is you don't have to comply with an exception or a safe harbor in order to not violate the law. So under the anti-kickback statute, if you comply with an exception or a safe harbor, then you're immune from prosecution. You fit within that safe harbor, and your arrangement is protected. But if you don't comply, then there's really a facts and circumstances analysis. And that's different than EKRA, where, as Katie mentioned, if you don't fit into an exception, you have been deemed to violate the law. And while I'm not aware of any enforcement actions under EKRA as of yet, although I agree with Katie that I think we all anticipate seeing enforcement in this area, we do know that the anti-kickback statute is being used as a tool for enforcement in this context and in this area specifically. So I wanted to highlight just two examples, and so you can see kind of the penalties and degree of enforcement that is being applied in this context. So in August 2018, Insys Therapeutics agreed to pay at least $150 million to resolve claims that they had paid doctors kickbacks to prescribe opioids. And as part of that, a former sales manager pled guilty for engaging in that scheme. And he was one of several executives and doctors who were charged. And then also in Florida last year, as part of a national fraud takedown, 4 individuals were prosecuted in connection with kickbacks received from SmartLab, which was a clinical laboratory in Florida. And the charges allege that SmartLab entered into employment agreements with sales reps to solicit bodily fluid samples from alcohol and treatment centers. Then SmartLab would conduct expensive confirmatory and medically unnecessary drug tests on samples and would submit claims to federal health care programs for those tests. And in exchange for those referrals, SmartLab would pay a portion of the reimbursement they receive from the federal health care programs to the owners, operators, and clinicians of the treatment centers. So 2 of the owners of SmartLabs received prison time. They had to repay $3.8 million in reimbursements back to the government and $70,000 in fines, and the company also received 3 years probation. So we know that enforcement in this area is alive and well, and that's part of the reason why we think this is just another tool that the government is likely to use. Let's go to the next slide. So as Katie already discussed, EKRA makes it illegal to knowingly and willfully solicit, receive, offer, or pay any remuneration in return for referring a patient to or inducing a referral of an individual to a recovery home, clinical treatment facility, or laboratory. And Katie also mentioned that EKRA applies to healthcare benefit programs, which is defined very broadly. So unlike the anti-kickback statute, it's not just limited to federal healthcare programs. It's all payers. And so now the government may monitor payment arrangements related to services that are reimbursed by either private health plans or government health plans. I have laboratory highlighted here because although recovery homes and clinical treatment facilities are defined in EKRA, and I see that somebody actually has a question that we'll get to about the definition of recovering homes. The definition of laboratory is quite broad, and I want us to spend some time just talking about that and what that may possibly mean. And since EKRA applies to all improper referrals to recovery homes, clinical treatment facilities, and laboratories, it really raises significant questions and concerns about how EKRA will be applied to laboratories in the future. So that's why I want to talk about that. Next slide, please. First, though, I want to talk about how the anti-kickback statute and EKRA are going to fit together and what it means for current relationships that were permissible under the anti-kickback statute, but that either are not addressed by EKRA, by the EKRA safe harbors, or addressed differently by them. So the law itself addresses the relationship to the anti-kickback statute to some extent, but not fully. The law suggests that it does not apply to conduct that's already prohibited by the anti-kickback statute. But the reality is that the anti-kickback statute only applies to federal health care programs. So it is possible that potential defendants can be charged under both laws for the same conduct, anti-kickback statute for federal health care programs and EKRA for all other payers. What's also less clear is what about conduct that is permitted by the anti-kickback statute. So Katie talked a lot about the elements of the employment safe harbor. And I will spend some time talking about that because it's significant that although both the anti-kickback statute and EKRA have employment exceptions, they vary, and how they vary is very meaningful in this context. Under the employment exception, remuneration does not include any amount by an employer to a bona fide employee for employment in the provision of covered items or services, and that's the employment exception for the anti-kickback statute. But EKRA, as Katie pointed out, requires that the payments to employees not be determined by or vary with the number of individuals referred, the number of tests or procedures performed, or the amount billed to or received from a payer. So what that means is that what may have been permissible under the anti-kickback statute may no longer be permissible under EKRA. So anti-kickback statute said as long as you have a bona fide employment relationship, you could potentially compensate an employee based on volume and value, and EKRA says you cannot do that anymore. For those entities that were not concerned with the anti-kickback statute because they did not accept federal health care program dollars, because of EKRA's applicability to all payers, those entities might now have to think about kickback compliance for the first time and may have to unwind things that they very intentionally entered into knowing that the anti-kickback statute wouldn't be applicable to them. Now they're left with having to do a review of their current arrangements. Another thing that is unclear in EKRA is the meaning of some of the terms. So Katie explained a lot of the terms to us, but it's significant to me that there are some terms that we don't know what they mean or how they'll be interpreted by EKRA. So for example, what does it mean to refer a patient or patronage? What does it mean use of service? And so I think we have yet to see that. While regulations will likely be promulgated to clarify some of this, right now entities are really left to figure out how to address EKRA with limited information and context. Let's go to the next slide. So I already emphasized why I wanted to spend some time thinking about laboratories in light of the very broad definition of what is a laboratory under EKRA. And as you can see, it really refers to the public health definition. So it's a facility for the biological, microbiological, serological, chemical, immunohematological, biophysical. I'm not going to read it, but you can see it's very, very broad definition of laboratory. It really means any clinical laboratory. And while we know the purpose of EKRA was to make it illegal to provide or receive kickbacks for referring patients to recovery homes or treatment facilities or for drug abuse-related testing, the inclusion of such a broad definition of laboratories is troubling because on its face it appears to address any laboratory service, not just those related to alcohol and drug treatment. So I think clinical laboratories in particular now need to review how they compensate their sales personnel in light of EKRA, really all arrangements that they have in light of the passage of this law. Existing employee compensation arrangements that complied with the anti-kickback statute may run afoul from EKRA, and it's really unclear how the law would apply to compensation paid to a laboratory employee that's based in part on the amount of business generated by that employee. And it's also unclear which law would apply. Would it be the anti-kickback statute or would it be EKRA? So I want to make note that the legislative history does not actually help us here. It doesn't provide a lot of context. So we're really left right now with some confusion and an overlap of laws. Next slide, please. So because there's so little context around EKRA and regulations have not yet been promulgated, we can look to the anti-kickback statute for some guidance on what may be viewed as problematic and what proactive steps companies can take now. From an anti-kickback statute perspective, while the particular facts and circumstances determine if there's an actual problem, we know that generally speaking, and Katie already hit on this earlier, arrangements with independent contractor sales reps that are paid on a per-test basis raise red flags. We also know that incentives based on patient volume and success-based marketing fees, that is, fees that are paid on the basis of a successful referral or, if you will, an admission, are also suspect. And I want to note that although the federal government has taken the position that sales personnel can be deemed to induce referrals, I think there's still some room to debate this based on actual facts and circumstances, and I'm not sure that has been fully litigated, so I think there's more to come on that, I guess I would say. But even without the regulations, based on the safe harbors we have, it appears that some of the same types of things that have been viewed as suspect in the anti-kickback statute will likely be viewed as problematic under EKRA. And again, we anticipate that it's only a matter of time, given the heightened focus in this area, before enforcement under EKRA begins. And I want to note, before I kind of get into what organizations should do right now, I want to note that many organizations may find themselves competing with entities that are still engaging in conduct that is viewed as problematic now because of the passage of EKRA. And we understand that, and we know that it's a very difficult place to be. But we really do think it is a best practice to start reviewing your existing practices and looking at how to unwind or alter particular arrangements that may have a heightened risk in light of EKRA. And as you do that review, and I can't stress this enough, it should be done with a very deliberate, methodical fashion. The purpose of the review is not to find everything that is wrong. Instead, it's really to evaluate current practices and determine where adjustments should be made. So some of the things that people might want to do are to review all existing arrangements with vendors and substance abuse treatment centers. To the extent that there are referral relationships, you should review the compensation methodology and whether the compensation is tied to referrals. You could review and audit all marketing activities. By way of example, what does the bonus structure look like for marketing representatives? Is it based on company performance or average monthly admission goals? You could review all arrangements with physicians. Are there certain interactions that could be construed as improper remuneration? And then, as we've already talked about, examine all of the employment relationships. And that's really something that's different, because up until this point, at least under Kickback, I think when we would hear employment, the person is employed, we would say, okay, there's less risk there. Now we can't take that liberty anymore, and so it's important to also examine all employment relationships, even if they're structured to comply with the anti-kickback statute employment exception. And then the next step after looking at all of those is to determine whether there are any relationships or arrangements that you want to unwind and how best to do that. And so I want to be clear that I'm not suggesting that every incentive-based relationship is going to be problematic, but an analysis, I think, has to be done on those incentive-based relationships and to determine if they are problematic or if there are some elements that maybe need to be tightened in order to reduce the risk. So you may determine, by way of example, that you no longer want to continue admission-based bonuses, but that doesn't mean that you can't have a bonus based on some other criteria that's not success-based. And before starting any of this review that I just talked about, I really think that organizations should consider the extent to which they want to engage counsel to assist with the review and the determination of next steps. A lot of this is not black and white, and there will be interpretation of the law, and so engaging counsel in those conversations and the review can be helpful in trying to figure out kind of what are the appropriate next steps without potentially having to unwind your entire business structure. I want to focus kind of on the future for a moment and talk about mitigation. So right now, it seems to me, as I've just kind of walked through, that organizations should really be focused on reviewing their existing practices and looking towards the future with regard to operating in a compliant manner in light of EKRA. It's unclear right now what, if anything, companies should do in the future if they find they violated EKRA. So we know it became effective in October 2018. I'm not talking about right now, but in 2 to 3 years in the future, what if you look back and go, wow, for the last year we have had an arrangement with the marketing person that may violate EKRA. What do we do about that? So under the anti-kickback statute, there's a process for disclosing potential violations of the anti-kickback statute to the OIG. We don't yet know if there will be a similar process developed related to EKRA. And it's something that we'll wait and stay tuned to see. Again, that's really something focused in the future, but I think it's something that we all have to be thinking about, because there will be times, even as everybody has implemented and maybe adjusted their arrangements to comply with EKRA, there will be times in the future where something runs afoul. And what can we do proactively about that as opposed to just waiting for a potential government enforcement action? Before I wrap up, I wanted to take a moment to discuss compliance programs. we would recommend that organizations start to develop compliance programs taking from some of the vast guidance out there related to federal healthcare program compliance programs. So while organizations may not develop a comprehensive plan that's focused on the 7 elements that are widely known in the healthcare industry, there are certain things that can be implemented to help protect the organization and demonstrate that the organization is trying to be compliant. So for example, an organization may start to develop policies governing sales representative interactions with referral sources, or policies related to incentive compensation to people in a position to refer. Or an organization may start to audit and monitor spending associated with referral sources. And these are just a few examples, but I think it is important for organizations to think about where they might enhance their compliance functions as they're also conducting a review of existing arrangements. So Katie and I provided you with a lot of information today. As Katie said, we're happy to take questions, and I do see, Katie, that we have a couple of questions already, and I think the first one, if that's okay with you, the first one I will read to you because it's really related to the definition of recovery home.
Sure. So, and before we do that, I just want to mention one thing. I noticed that the email address that's on this slide is incorrect for me, so we can send, I guess, update that. But it's Nelson Hardiman. It's, M-A-N. So anyway, just wanted to tell people that in case you want to contact me.
Thanks, Katie. So the question is, I have concerns regarding the definition of recovering home specific to treatment. I think that's it. Do you have any thoughts, Katie, on that?
So the definition of recovery homes is extremely broad, and here in California, we have a specific laws and regulations regarding addiction treatment facilities, and you must have a license, and you may have a certification. So you must have a license for a residential treatment facility, which is a non-medical facility that provides, treatment and recovery for drug and alcohol addiction. And so that would be under that definition, as well as it's broad enough to include, sober living or transitional living facilities. So it's very broad. That's all I'm happy to answer a more specific question if they have one.
There's another question about how aggregators fit into the framework. In other words, a website that produces calls that are forwarded to a provider's internal call center, aka a call aggregator.
So that would be probably a very fact-specific analysis, which we'd be happy to do. But, the general rule is that you may not pay for referrals. So you can't, a company, a residential outpatient facility couldn't pay, or even a sober living under this law, couldn't pay that aggregator for sending them clients. That would violate this law if they were paying on a per patient basis. There's other issues with aggregators that come up that don't have to do with this law regarding deceptive marketing practices that are very important as well to keep in mind. So that is being investigated as well, and the FTC will probably be the enforcement body for that, Federal Trade Commission.
Great. There's another question asking for some other examples of what a company can base bonus payments on for bona fide call center and marketing employees. You mentioned effort and company performance. I will add a couple, and then Katie, you can also add some. In the context of marketing employees, you could look at a number of sales calls made, customer satisfaction, number of sales meetings scheduled, customer service. Katie, what else do you have?
Also just overall, I think one of the best indicators is just the overall success of the business. So if the business is doing really well, that means that, at some level your marketers are working hard and doing a good job to bring in clients. So that, I think, is an important factor as well.
And it looks like our final question so far is, with insurance companies barely paying for 7 days of acute care/detox treatment, people being transferred to sober living are really quite sick. Now in a residence with no medical oversight is my concern.
Sorry, what was the last part?
Now in a residence with no medical oversight is my concern.
So I'm not sure that question, I mean, I agree with that, obviously, but
yes.
I'm not sure it relates to the enforcement of EKRA, really. I mean, that's a patient care issue and an issue with the insurance companies not approving, care that is actually medically necessary. And it's difficult, and that's a shame.
Yeah, I agree.
The only question, I don't know how to see the questions on here, I apologize, but I had a question just, I wanted to hit on, because we get this question a lot from our clients, just based on your experience, what do you expect to see regarding or relating to enforcement? I know you talked about it a little bit, but.
Yeah. I mean, I expect to see enforcement through this law. I think it may take a little while, because I think I would expect to see some regulations promulgated, so I think there's a process that's going to have to be gone through in order to do that. But I don't think that means that people should just kind of ignore it. We know it was effective in October. Even if it takes a couple of years for enforcement, there's still a statute of limitations that may apply for the kind of that time frame. And as I said kind of throughout the presentation, I think there's enough here that we can at least have some glimpses of what type of conduct would be more problematic and what would be less problematic. So just because there's no enforcement now, I don't think it's safe to say there will never be no enforcement. I think that's very unlikely, especially in light of the enhanced focus on just drug addiction in general from all the various aspects of the government. We also know just from fraud enforcement in general, it's very lucrative for the government. So this is a tool that now has expanded their ability to go after people, especially, as we said, the way it's drafted with laboratories for all payers. And so I can't imagine that it's not going to be enforced.
And just to add on to that, when she talks about statute of limitations, if you don't know what that is, it means, there could be a look-back period where they could go back, and there's a certain time period where they could say, well, you were violating the law, 2 years ago, or whatever the limit is. And also there's another issue to keep in mind, which is whistleblowers. So anyone in your, an employee that you have or anyone working with you could inform the government, that enforcement agency, that there's been a violation. So that's something to keep in mind as well. And then the last point I would make is, even if this law is not enforced right now, at some point it will be enforced, and at that time, if you don't have a mechanism in place to actually acquire clients and patients in a legally compliant manner, you won't be able to operate your business going forward.
Yeah, and Katie, I think we talked about this a little bit. Somebody will be the poster child. You don't want to be the poster child. At some point, it will be enforced, and you don't want to be the first one.
Great.
Okay, I think that's all the questions we have.
Thank you, Katie and Anjali. This concludes today's webinar. As a reminder, in 2 to 3 business days, Epstein Becker Green will email registrants a link to access a recording of the presentation and PowerPoint materials. Thank you for attending.